Today, let us discuss the directive principles of state policy of the Indian Constitution. India, from its inception, adopted the principle of welfare state. This goal is enshrined in Part 4 of the Constitution under the title Directive Principles of State Policy. The features of Directive Principles of State Policy are as follows. First one, resembles instrument of instructions. The directive principle resembles the instrument of instructions which are enumerated in the Government of India Act 1935. According to Dr. Ambedkar, these instructions were issued to the Governor General and the governors of the colonies of India, while the directive principles are instructions to the legislature and the executive. Second, welfare state. The directive principles promote social, economic, and political justice. These ideals set the foundations for a modern welfare state. Third, good governance. The directive principles are ideals which the central as well as state governments should keep in mind while formulating policies and enacting laws. Fourth, non-justiciable. The directive principles are non-justiciable, thus they are not legally enforceable by the courts for their violation, and the governments cannot be compelled to implement them. Fifth, aids judiciary. Though non-justiciable, they help the courts in examining and determining the constitutional validity of a law. Sixth, not static. The directive principles are not static. They can be amended or repealed by the Parliament according to the needs of the people. For example, the 97th Amendment Act 2011 added a new directive principle relating to cooperative societies. Thus, the directive principles cover a wide range of issues. The purpose of directive principles is to attain social and economic goals through a non-violent revolution which enables a common man to fulfill his basic needs. The directive principles have been described as the novel features of Indian Constitution by Dr. Ambedkar. The reasons for making directive principles non-justiciable and non-enforceable. The reasons are as follows. First point, diversity. The vast diversity and backwardness in the country would stand in the way of their implementation. Second, no resources. The Indian nation did not have the resources for immediate implementation, and so founders left it for future governments to implement them as and when resources could be found. Thus, the founders took a pragmatic view and refrained from giving teeth to these principles. They held that the awakened public opinion rather than the court for the fulfillment of these principles. Classification of directive principles. The Constitution does not contain any classification of directive principles. However, on the basis of their content and direction, they can be classified into three broad categories. A. Socialistic principles. These principles aim at providing social and economic justice and sets the path towards the welfare state meant for creating an egalitarian society. B. Gandhian principles. These principles aim at fulfilling the dreams of Gandhiji, who had sponsored constructive programs for the upliftment of the Indian village masses during the national movement. C. Liberal intellectual principles. These principles aim to reflect the ideology of liberalism. The state must act firmly at the appropriate time to put an end to injustices prevailing in society. Let us now discuss the various articles under directive principles of state policy. Article 38 states that the state will promote the welfare of the people by securing a social order permeated by justice, social, economic, and political, and to minimize inequalities in income, status, facilities, and opportunities. The initiative taken to ensure this directive principle are Pradhan Mantri Awas Yojana, Public Distribution System, Manrega, establishment of the National Commission of Scheduled Castes, establishment of the National Commission of Scheduled Tribes. Article 39 states that the state will secure A. the right to adequate means of livelihood for all citizens, B. the equitable distribution of material resources of the community for the common good, C. prevention of concentration of wealth and means of production, D. equal pay for equal work for men and women, E. preservation of the health and strength of workers and children against forcible abuse, F. opportunities for healthy development of children. The initiative taken to ensure this directive principle are Integrated Child Development Scheme, Minimum Wages Act of 1948, Equal Remuneration Act 1976, Rural Livelihood Mission and Urban Livelihood Mission, Promotion of Self-Help Groups, Mission Indradhanush. Article 39A states that the state shall provide free legal aid to the poor to ensure access to justice for all citizens. The legal system is too complex for a common man to understand. Moreover, legal procedures cost money, which the poor cannot afford. This directive policy ensures that justice is not denied to anybody. The initiatives taken to ensure this directive principle are National Legal Service Authority, and Nyay Mitra scheme. Article 40 states that the state shall take steps to organize village panchayats and endow them with necessary powers and authority to enable them to function as units of self-government. During the British period, the panchayats were deprived of their functions, and this directive principle revived and restored their powers. The 73rd and 74th Constitutional Amendment Act 1992 and Panchayats Extension to Scheduled Areas Act 1996. Article 41 states that the state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement. The initiative taken are Manrega Act 2005, Persons with Disabilities Act 1995, Maintenance and Welfare of Parents and Senior Citizens Act 2007. Article 42 states that the state will make provision for just and humane conditions of work and maternity relief. The initiative taken are Prime Minister's Maitritwa Vandana Yojana and Maternity Benefit Act of 2017. Article 43 states that the state will endeavor to secure a living wage, a decent standard of life, and social and cultural opportunities for all workers. The initiative taken are Social Security Act 2008 and Atmanirbhar Bharat Rojgar Yojana. Article 43A states that the state will take steps to secure the participation of workers in the management of industries. This will give self-respect and incentive to work. The initiative taken are labor laws such as Factories Act 1948, Industrial Dispute Act 1947, Contract Labor Act 1970, Trade Union Act 1926, Amalgamation of Labor Codes. Article 43 states that the state will endeavor to promote cottage industries on an individual or cooperative basis in rural areas. This can be a source of supplementary income for rural families. The initiative taken are Khadi and Village Handloom Boards, Khadi and Village Industries Commission. Article 43B states that the state will promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. The initiative taken are establishment of the Ministry of Cooperation, Yuva Sahakar Cooperative Enterprise Support and Innovation Scheme 2019, National Cooperative Development Corporation Act 1962. Article 44 states that the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. This was essential to ensure national unity and integrity. The initiative taken are Special Marriage Act 1954, Hindu Code Bill 1956. Article 45 states that the state shall provide early childhood care and education for all children until they complete the age of 6 years. The initiative taken are Integrated Child Protection Scheme, Beti Bachao Beti Padhao Scheme. Article 46 states that the state shall promote the educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections of the society, and to protect them from social injustice and exploitation. This was essential to provide special support to these vulnerable sections. The initiative taken are reservation in education and employment for scheduled castes, scheduled tribes, and other backward classes in IITs, IIMs, and other institutions. Post-metric scholarship scheme, reservation in parliament and state legislatures, and the National Commission for Scheduled Castes and Scheduled Tribes established to safeguard their rights and interests. Article 47 states that the state shall make efforts to raise the level of nutrition and the standard of living of its people and improvement of public health. The state will endeavour to prohibit the consumption, except for medicinal purposes, of intoxicating drinks and drugs which are injurious to health. The initiative taken are National Food Security Act 2013, Poshan Abhiyan, One Nation, One Ration Card. Article 48 states that the state shall endeavour to organize agriculture and animal husbandry on modern and scientific lines and take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draught cattle. The initiative taken are Rashtriya Gokul Mission, E-NAM, Social Health Card Scheme. Article 48A states that the state shall endeavour to protect and improve the environment and to safeguard forests and wildlife. The initiative taken are Wildlife Protection Act 1972, Environment Protection Act 1986, Biological Diversity Act 2002, Green India Mission. Article 49 states that the state shall endeavour to protect monuments, places, and objects of artistic or historic interest which are declared to be of national importance. The initiative taken are National Historic Preservation Act 1966, the Ancient Monuments and Archaeologic of Sites and Remains Act 1958, Antiquities and Art Treasure Act 1972. Article 50 states that the state shall endeavour to separate the judiciary from the executive in the public services of the state. The initiative taken are Doctrine of Separation of Powers is a part of the basic structure of the Constitution. Independence of judiciary is a part of the basic structure of the Constitution. Article 51 states that the state shall endeavour to A. To promote international peace and security. B. Maintain just and honourable relations between nations. C. Foster respect for international law and treaty obligations in the dealings of organized peoples with one another. And D. Encourage settlement of international disputes by arbitration. The initiative taken are Non-Alignment Movement, Panchasheel, UN peacekeeping operations. Criticism against directive principles of state policy. They are as follows. First one, non-justiciable. The directive principles have been criticized because of their non-justiciable character. Therefore, it has been compared with a check on a bank, payable only when the resources of the bank permit. The directive principles are no better than the New Year's resolutions which are broken on the 2nd of January. Second, not logically arranged. The directive principles are neither properly classified nor logically arranged based on a consistent philosophy. The way they are arranged clearly shows that unimportant issues is mixed up with important socio-economic issues. At the same time, there are provisions based on reason and science is mixed up with sentiment and prejudice. Third, conservative. Critics have held that the directive principles are based on the political philosophy of 19th century England and are unsuitable for 21st century India. Fourth, ignoring social realities. The directive principles fail to address the complex, diverse social, economic realities, resulting in policies that may not effectively address the needs of all citizens. Fifth, constitutional conflict. The directive principles lead to constitutional conflicts which are as follows. A. Between center and states. The center can give direction to the states with regard to the implementation of these principles, and in case of non-compliance can dismiss the concerned state government. For example, the central government, for implementing Article 46, may direct states to establish special schools or scholarships for scheduled castes and scheduled tribes to enhance their educational opportunities. B. Between President and Parliament. The President may reject a bill that violates directive principles. For example, in 1991, the economic reforms was not signed by President R. Venkatraman, who had reservations about economic reforms and its impact on the principles of social justice. C. Between governor and state legislature. The governor may reject a bill that violates directive principles. For example, in 1986, the governor of Tamil Nadu rejected a bill that sought to provide reservation for backward classes in educational institutions on the grounds that the bill went against the directive principles as enshrined in the Constitution. Sixth, conflict with fundamental rights. Some directive principles often conflict with fundamental rights, creating challenges of balancing competing interests. For example, Keshava Anand Bharati versus State of Kerala, 1973, Minerva Mills versus Union of India, 1980, State of Kerala versus N. M. Thomas, 1976. Utility of directive principles. M. C. Chagla, former Chief Justice of India, stated that if all these principles are fully carried out, our country would indeed be a heaven on earth. India would then be not only democracy in the political sense, but also a welfare state looking after the welfare of its citizens. Dr. Ambedkar had pointed out that the directives have great value because they lay down that the goal of Indian polity is economic democracy as distinguished from political democracy. The directive principles do not confer legal rights nor create legal remedies, but they are significant and useful in the following ways. First, recommendations. They are general recommendations to all authorities in the Indian Union, which reminds them of the aim of building a new socio-economic order. Second, guiding light to courts. They help the judiciary in determining the constitutional validity of a law. Thus, they act as guiding lights to the courts. Third, helps to realize. They help to realize the ideals embodied in the preamble to secure to all citizens of India justice, liberty, equality, and fraternity. Fourth, framework for state actions. They constitute the framework for all legislative and executive actions undertaken by the state. Fifth, provide stability. They provide stability and continuity in domestic and foreign policies across political, economic, and social spheres in spite of the changes of party in power. Sixth, supplement. They supplement the fundamental rights by providing social and economic rights. Seventh, conducive atmosphere. By striving to establish socio-economic democracy, they create a conducive environment for citizens to enjoy their fundamental rights. Eighth, measure government performance. They aid the citizens and the opposition to examine the policies and programs of the government. Thus, they serve as parameters to measure the performance of the government. Ninth, recognize a ruling party, irrespective of its political ideology, has to recognize that these principles are a guide in its legislative and executive actions. Difference between fundamental rights and directive principles of state policy. First point, fundamental rights are negative as they prohibit the state from doing certain things. Directive principles are positive as they require the state to do certain things. Second, fundamental rights are justiciable in nature as they can be enforced legally by the courts if there is violation. These have legal sanctions. Directive principles are non-justiciable in nature as they cannot be enforced by the courts if there is a violation. These have moral and political sanctions. Third, fundamental rights aim to establish political democracy. Directive principles aim to establish social and economic democracy. Fourth, the courts can declare a law unconstitutional if it violates fundamental rights. The courts cannot declare a law unconstitutional if it violates directive principles. Fifth, fundamental rights are individualistic in nature as they promote the welfare of the individual. Directive principles are societarian in nature as they promote the welfare of the community. Sixth, the violation of fundamental rights is punishable. The violation of directive principles is not punishable. Seventh, fundamental rights is embodied in Part 3 of the Constitution. Articles 12 to 35 deal with fundamental rights. Directive principles is embodied in Part 4 of the Constitution. Articles 36 to 51 deal with directive principles. Eighth, the basic rights that are guaranteed to citizens of India. They are guidelines to be followed by the government while framing policies. Ninth, fundamental rights can be suspended during a national emergency. Directive principles can never be suspended under any circumstances. 10th, fundamental rights was borrowed from the Constitution of United States. Directive principles was borrowed from the Constitution of Ireland, which in turn borrowed it from the Constitution of Spain. On one hand, the fundamental rights and directive principles are complementary because fundamental rights aim at securing social and economic justice, liberty of the individual, and equality of status and opportunity, while directive principles lay down the principles which ought to guide the state in making laws for securing these rights and to achieve a just society. On the other hand, the fundamental rights and directive principles are in conflict. For example, right to property might conflict with policies aimed at land reforms. Thus, fundamental rights and directive principles are intended to work together to ensure both individual rights and collective good.